Hello and welcome to part 2 of this Field Seymour Parks webinar. This is investigation, medical evidence and disability. So that's what I'm going to be talking about in part 2. So investigation and evidence, really the purpose of investigating an employee's absence on long-term sick leave is to understand the cause of their absence. So why is it that they are off work at the moment and unable to perform their duties? The duration of that absence. So what's the prognosis for their return to work? Are they going to be able to return to work in the foreseeable future or not? And then in addition, what are the adjustments that you might be able to make as an employer to facilitate that employee's recovery and return to work? So that in a nutshell is what we're looking to do when we're investigating an employee's absence on long-term sick leave. Really, I suppose the first step here is reviewing the initial GP statement of fitness for work, or fit notes, sick notes as you may know them, and seeing what it says on that fit note about why the employee is unable to work. As I said in part 1, this really gives you the first clue as to what's causing the employee's absence. But I think it's fair to say that these GP statements of fitness for work, they're unlikely to go into very much detail about the underlying health condition. Sometimes you'll only have a word or two, like depression or stress or something like that, or bad back. And really that doesn't give you enough to work on as an employer in terms of understanding what the reason for the absence is, how long it's going to last, and when you can actually expect this employee to be back working for you. So for that reason, it's the vast majority of cases advisable to obtain a GP or occupational health report, and I'll talk a little bit more about the options you've got there in a moment. I think if you've done a little bit of investigation into why an employee is off sick, sometimes you might have some doubts about the legitimacy of their absence, and I just wanted to briefly run over some of the points to bear in mind here. Sometimes you may see perhaps from a social media account or hear from a colleague that an employee's gone off on a nice holiday, they're sunning themselves on the beach, and you're thinking as an employer, well, hang on, you've said you're not fit to work, what's going on here? But the key point to remember is that inconsistent with what the employee has told you about the nature of their health conditions? So if they're feeling stressed and perhaps it's gone beyond stress to a clinical mental health issue, then actually some time away relaxing might be exactly what they need to recover and return to work in the near future. Likewise, if you've got information that somebody's done some sort of crazy endurance challenge, sort of been off running marathons or hiking up mountains or climbing Everest or something, again, it's a case of, does that actually contradict what I've been able to find out through my investigation about the reason for absence? So again, if the reason for the employee's absence isn't a physical health condition but a mental one, then there's not necessarily any sort of dishonesty or foul play going on there, and it's important to bear that in mind. Clearly, if they've told you that they can't get out of bed because they've got some serious issue with their legs or another part of their body, they can't walk or can't move properly, then it's going to be a different story. But I'd avoid just jumping to conclusions if you see something which doesn't immediately match up with what you're expecting for somebody on long-term sick. In contrast, if you find out that your employee who's off on sick leave is actually carrying out work for another employer, then a lot of the time that's likely to give you grounds for initiating a disciplinary process and potentially a misconduct-based dismissal, particularly if they are working for that other employer during the same hours that they're contracted to work for you, because in that scenario they're likely to be receiving two lots of pay, so either company sick pay or SSP from one business, and then pay based on an hourly rate or annual salary from the other employer. So in that situation you're probably well placed to take robust action against that employee. However, I would just caveat that by saying that if the reason that the employee is unable to work for your business is again some sort of breakdown in communications with colleagues or a manager, and the issue in that respect is not at play in the work that they're doing for the alternative employer, then it may not be so cut and dry. So again, I would just caution against any sort of hasty response. Make sure you've got all the facts in front of you before you take any radical action. Final point just on this slide to bear in mind is potential stress at work issues. So has your investigation uncovered issues with the amount of work or type of work, perhaps the quality of supervision that the employee is receiving, and are there any steps that you can take as an employer to remedy any deficiencies in that respect? So your investigation gives you an opportunity to find out more, as I say, about the underlying cause for the health problem. Is it work related? What can you do? What steps can you take as an employer to help facilitate that employee's return? Medical evidence then. I think the first point to emphasise is that the onus is not on the employee to come to you and reel off their medical history and tell you about why they're off work and when they're going to be back. The onus is on you as an employer to take those steps and find out about what is causing this absence. As I've covered already, you do need to request fit notes when an employee has been off work for more than 7 days. And those will give you some idea as to what the reason for the absence is, but probably not enough. So the next step in terms of improving your understanding of what's causing the employee's absence on long-term sick leave is to get hold of a GP or occupational health report. Now, there's no real right or wrong here in terms of how you go about obtaining a report, and specifically whether you choose a GP or occupational health report. The key point is that you need to acquire some objective medical evidence about the nature of the illness and when the employee may be able to return, and what you as an employer can do about it, whether any adjustments you can make. So both the GP and the occupational health report should serve that purpose. Personally, I tend to advise in the majority of cases that my clients seek an occupational health report, and the reason for doing that is that often that is a much quicker route than going down the GP report route. So there's often a delay. GPs are very, very busy often, got a lot to get through, and getting hold of a GP's report can often take some time, whereas as an employer you want to gain an understanding of the health issue a lot more quickly. An occupational health report generally allows you to do that. Another point to bear in mind with this decision, so it's like a GP report or occupational health report, is that with a GP report, the Access to Medical Reports Act 1998 will apply, and that gives the employee the right to review reports before they're returned to you. You need to write to them in advance of getting a GP report to obtain their consent. And again, it's another layer of bureaucracy to go through, which lengthens the time that you'll have to wait, in all likelihood, before you receive a GP report. Also, in my experience, I do find sometimes that the GP is obviously aware of their duties, duty of care to the patient that they're seeing, and sometimes the reports are, shall we say, protective of that employee's position, whereas you will sometimes get more of an objective report from an occupational health professional, and that report will hopefully be geared towards what the impact of the employee's absence is on you as an employer and how it relates to the duties that you're employing them to do. Sometimes GP reports, again in my experience, can be quite technical in terms of the language that they're using, and the focus can be on the specific medical terms and treatments that are being explored, rather than what the practical effect is of the employee's absence with regards to their ability to perform their duties at work. But having said that, in some circumstances, a GP report may well be preferable. Perhaps if the GP has a very thorough, detailed understanding of the health issues that an employee is going through, then they may well be the most appropriate person to comment. And if you're aware that there's a long-standing relationship between the employee and the GP, and you failed to request a report from that GP, then that decision could possibly be open to challenge further down the line when you're trying to show that you've acted reasonably in all the circumstances, and you've obtained appropriate medical reports. So something to bear in mind, as I say. Obtaining a medical report is a process that really you ought to give some thought to as an employer. It's a good opportunity to ask focused questions of the medical health professional that you're dealing with about what the prognosis for the employee's return is and what they can and can't do, with specific reference to the duties that they have for you and what they're expected to do. So think about providing a copy of the employee's job description, for example. That will help the medical professional understand what it is that the employee is employed to do, and ask focused questions about whether they are or are not able to do the core parts of their role. So, for example, if they're involved in warehouse work and they're required to move heavy boxes around, is there any limit on what sort of weight they can be expected to handle, or a length of time when they might need a rest break in order to recover? Try to ask those specific practical questions linked to what the employee is actually expected to do in practice, as opposed to more general queries. And on that point, I think because of the duties that apply to disabled employees, employers are often looking for an answer to the question, is my employee disabled under the Equality Act 2010? And you can ask that question, but I would just say don't expect a straight answer to it. It's a bit like trying to get a yes or no answer from a politician. It's just not going to happen, really. They're aware, these medical professionals, of the implications if they come down firmly one way or the other on the question of disability, and they're probably just going to throw the ball back in your court. So you might get lucky, you might get somebody who's willing to stick their neck out a little bit more on that question, but in my experience the medical experts tend to dodge that a little bit and hide behind the legislation. Not always the helpful response that you might prefer. So once you've got the report back from the GP or the occupational health person, what do you do with it? How do you assess that? Can you take it at face value? Well, ordinarily, yes, they're experts. You've engaged them to prepare a report, and you're entitled to rely on that. I would only just caution that if the report seems completely at odds with your own understanding of the employee's health condition as they've previously reported it to you, then you just probably need to go back and query that with the professional to make sure that your understanding is correct. Another issue that can sometimes arise if you've got two reports, perhaps you've commissioned an occupational health report at the same time as asking for a GP report. You receive both back, they're at odds with one another. Clearly in that situation you're going to need to make some further inquiries as to which report is accurate. So if there are any minor discrepancies, it might not be necessary to follow up, but if they're fundamentally at odds with each other, then clearly that doesn't really leave you best placed and well informed to make decisions moving forward about what this employee can do and when they might be able to return to work. So the next slide, I'm going to talk about disability, assessing your duties to disabled employees and whether a disability arises on the facts. So when you've got someone on long-term sick leave, there is a tendency to think, oh well, they must be disabled almost automatically because they're off and they're not able to perform their duties. That's not necessarily the case. Often there will be a disability there, but the key issue to consider here is, are they disabled under the definition of disability, which is at section 6 of the Equality Act 2010, and that definition is up on the slides now, and I've underlined a few key words there. So disability under the Equality Act, it's either a physical or mental impairment which has a substantial and long-term adverse effect on a person's ability to carry out normal day-to-day activities. So why have I underlined those words? Well, firstly, physical or mental, just to drill home on that point that it's possible for somebody to be disabled with a mental health issue as well as a physical health issue. Substantial in this context just means more than minor or trivial, so it's quite a low bar to clear. Long term means it's lasted, the illness or injury has lasted for 12 months, or in the alternative that it's likely to last for 12 months, or sadly for the rest of the individual's life if the prognosis is very poor. And then normal day-to-day activities should really just be given its standard meaning. So we're looking at things like cooking, washing, being able to get dressed, go for walks, make a cup of tea, all the sort of normal activities you'd expect somebody to be able to do without difficulty. There isn't a particular requirement for somebody's illness or injury to have a medical diagnosis. So if the doctors, the experts aren't sure what the issue is, that doesn't prevent somebody from being disabled. You're always going back to that Section 6 Equality Act definition, and applying that to the specific facts. And in terms of the medical treatment that somebody's receiving, you need to disregard the impact of that treatment for the purposes of assessing whether somebody is disabled. So if somebody's generally able to cope without too much difficulty because of the medication that they're receiving, that doesn't prevent them from being disabled under the Equality Act. You strip away the effects of that medication when you're making the determination as to whether or not they are disabled. On the next slide, I've put a few examples of disability. So the first bullet point actually slightly cuts across what I've just said about the importance of that Section 6 Equality Act definition, because there are some conditions that are recognised as disabilities even though they might not technically meet that definition, and I'm thinking of illnesses like cancer and HIV. Those are automatically recognised as disabilities in any event. A common query that I receive from clients is, what about stress? Can stress amount to a disability? And the stress, not on its own ordinarily, not on its own a disability, but it can worsen and give rise to recognised mental health conditions such as clinical depression or anxiety. So there's a distinction to be drawn there between somebody who's actually been diagnosed with a mental health condition and somebody who's just feeling a bit under pressure and stressed out by the work that they're doing. Obesity is one example that I thought I'd touch upon, perhaps not something that you would ordinarily think of as qualifying as a disability. But there's an interesting case that went before the European Court of Justice on this point. It's up on the slides, Kaltoft and Billund Kommune, a Danish case. And the upshot of that case was that if you have a situation where somebody is not able to participate in professional life on an equal footing with others because of their condition, then that will strongly indicate that they are suffering from a disability under the Equality Act. There's no sort of BMI linked threshold that applies there, so that there's no sort of distinction between being obese or morbidly obese or other sorts of categories. And there's also no sort of suggestion, I mean, it was completely rejected by the ECJ that whether or not you'd contributed to your own disability could be a material factor. So if somebody's obese because of just overeating and a poor lifestyle, that doesn't prevent them from benefiting from the protections that are afforded by the Equality Act and other legislation to disabled employees. Another one that I've just stuck up there is nut allergy. Again, you might think not, but there's a case, Andy Arami, where somebody with a very severe nut allergy was actually deemed to be disabled under the Equality Act. I think in that case, I'm probably right in saying that the allergy was so severe that just sort of having nuts around in the general vicinity would have set off a reaction. That leads me on to the last point on that slide, which is talking about avoiding action, modifications to behaviour. So you could draw a distinction there between somebody who, in reality, isn't really in control of their situation because you can't prevent other people from eating foods that you might have a severe allergy, a severe allergic reaction to. Whereas if that allergy is only brought on by you yourself eating those foods, so nuts or whatever it might be, then you can reasonably be expected to avoid that behaviour, and in those circumstances, the nut allergy or other similar allergy wouldn't amount to a disability under the Equality Act. So the methods that you can take to avoid the effects of a health condition can be relevant in some circumstances. So if you do have a disabled employee, they're going to qualify from protection against discriminatory treatment, and I've got up on the slide there a summary of the key protections that are afforded to disabled employees. So you've got direct discrimination under Section 13 of the Equality Act 2010, and that's where an employee is treated less favourably because of their disability. Indirect discrimination, in contrast, that's where you've got a policy of the employer. So the legislation actually talks about a provision, criterion or practice, but just to summarise, we're talking about some form of policy that the employer has in place. That places the disabled employee at a particular disadvantage when compared with those employees who don't share the individual's disability, and the treatment of that employee as a result of the policy that's been put in place can't be objectively justified as a proportionate means of achieving a legitimate aim. So that's indirect discrimination, and that's Section 19 of the Equality Act. Finally, on this slide, discrimination arising from disability, which is Section 15 of the Equality Act. Here you're just looking at whether an employee is treated unfavourably. So you don't have the complicating issue of identifying a comparator, which can sometimes make this an easier claim for employees to bring. So have they been treated unfavourably as a result of something arising in consequence of their disability? If so, they'll have been subjected to unlawful discriminatory treatment, unless you as an employer can show that their treatment was justified. And again, we're looking at justified as a proportionate means of achieving a legitimate aim. In addition to these issues of direct, indirect discrimination, discrimination arising from disability, there's also the question of reasonable adjustments. And where you have a disabled employee that's been placed at a disadvantage by a policy of the employer, by a physical feature of the employer's premises, or by a failure to provide some form of auxiliary aid. So I'm thinking here about hearing aids or documents in Braille format perhaps, then under Section 20 of the Equality Act 2010, you are under a duty to make such adjustments as it is reasonable to make in the circumstances in order to reduce the disadvantage that that employee experiences. So that's the duty to make reasonable adjustments. Now, this is always going to be fact sensitive, and in a minute I'll run through some of the potential adjustments that you can make and when it may be reasonable or not for you to make those sorts of adjustments. The key point with reasonable adjustments is to make sure that you're recording the rationale for your decisions about whether you will or won't do something, whether that's arisen as a result of a suggestion made in a GP or occupational health report, or whether that's something that the employee has suggested themselves, or whether it's something that's been brought up by the employer's HR team perhaps, or management in discussions. So the next slide, as I say, potential adjustments, and I've listed a few out here. The first one on that list, phased return to work. So this is something that a lot of employers will be familiar with. Phased return to work is pretty common, where you're reintegrating somebody back into the workplace. And a question we often get actually on this point is, do I have to maintain full pay for an employee as their employer when they are coming back to work on a phased return basis? And generally speaking, the answer is that you don't have to maintain full pay, because you're not receiving full performance by the employee of their duties under the contract of employment. However, there's always a caveat, and a caveat is normally check the terms of the contract of employment and the terms of any employee handbook, because if that says something to the contrary, then clearly you will need to maintain full pay, and if you fail to do that, then there's a potential claim against you as an employer. The next point on that slide, change in duties or role. Really, if somebody is able to do part of their role but not other parts as a result of their health condition, then you could consider bringing them back into the workplace but tweaking their duties so that they're focused on that aspect of their role that they can do, and reassigning those aspects of their role that they're finding difficult to somebody else. The third point, changing work locations. So are they able to work at an alternative location, perhaps closer to their home if you've got multiple offices, or even working from home? Do you have the IT or other facilities needed to enable that to happen? If so, that's a potential adjustment that you could make, perhaps where an employee is not physically mobile, not able to travel. Fourthly, looking at a reduction in hours or different hours. So if the employee for some reason is finding it difficult or stressful to travel at certain times of the day, or they just need to work reduced hours, or maybe have a high number of breaks during the course of the day to allow them to overcome the health issue, the disability that they are dealing with. That's another adjustment to be considered by you as an employer. Specialist equipment. So is there anything that you can bring in, that you can provide? So, think of particular types of desks or chairs, other sort of specialist equipment. I mean, it's probably going to vary from one industry to another, but again, something to bear in mind. Providing extra training. So if the employee, as a result of their disability, is struggling to learn new processes as quickly as others, then you may need to provide extra training sessions to them in order to help them come up to speed. Again, another thing to consider. One point that's actually not on these slides, which I should mention as well, is the general query of maintaining full pay. So exercising your discretion, I should say, to maintain full pay during a period of sick leave. And there are a couple of cases on this. There's one called Makel and one called O'Hanlon, and these sort of they draw a distinction on this issue based on the extent to which the employers had contributed to the disability through their own conduct. So in Makel, the Court of Appeal, they're both Court of Appeal cases, found that the employer had sort of exacerbated the situation itself through its poor handling of the case, and as a result, in those particular circumstances, it was reasonable for them to have to maintain full sick pay for a period of time. In O'Hanlon, the Court of Appeal came to a different conclusion and decided that as the employer had otherwise taken all steps that it was reasonable for it to have to take to support the employee, it wasn't then a requirement for that employer, it wasn't reasonable for that employer to have to maintain full sick pay. So if you as an employer have made the situation worse, then unfortunately there's a risk that a court or a tribunal might find that maintaining full sick pay is a reasonable adjustment for you to make. If you're otherwise satisfied that you've been doing all the right things, then you probably won't have that burden placed upon you. So that's another reason why it's so important to handle these situations with care, with sensitivity, and properly, following a good, robust procedure. So I've looked at the potential adjustments you can make. What about the factors that are at play when considering whether or not it's reasonable to make that adjustment? And there's some helpful guidance on this. The Equality and Human Rights Commission Code of Practice on the Equality Act 2010 lists a series of factors, and they're up on the slide now. The first one on there, the extent to which the adjustment would have ameliorated the disadvantage. So basically just, would it have made any difference? Would it have helped that employee recover or return to work? Financial and other costs of making the adjustment. But I would sound a note of caution here. If you're looking at relying exclusively on cost grounds, then you're possibly on a bit of a sticky wicket. The EHRC code makes it clear that you as an employer are expected to consider costs in the round. So yes, there may well be a cost to you of making a certain adjustment. You might consider that cost to be quite high. But what does that cost look like when you weigh it against alternative options? So if you consider, for example, the recruitment costs of bringing somebody else in, training them up to do the work, it's not a case of just looking at the cost of making an adjustment in isolation. It's important to compare them to the alternative and place them in context, when you are assessing the reasonableness of making an adjustment. The third point on this slide, financial and other resources of the employer. Unfortunately, if you're a larger employer, there's probably going to be an expectation that you will do more. You've got the financial and other resources that allow you to stomach some of these amendments, more so than smaller or medium-sized enterprises. However, that's not to say it's a kind of get out of jail free card. If you're a smaller employer and you just say, well, I don't have the money as a smaller employer, you still need to apply your mind to the reasonableness of making an adjustment a little more than that. The fourth point, the extent to which the adjustment was practicable to make. So someone might come up with a great adjustment. Is it actually feasible in practice? Availability of third-party assistance. So are there, for example, any grants, or is there charity assistance, for example, that you could call upon to help you put something in place? And then the sixth point there, nature of employers' activities. So if somebody's off sick with an illness or injury which is very closely related to the sort of work you do as an employer, you may be expected to go further in terms of making reasonable adjustments to support that employee. So that's that brings me to the end of this part 2. If you've enjoyed listening to part 2, then please do join me for part 3, where I'm going to be looking at consultation and fair process, dismissal process. Any questions or queries, feel free to contact me. My details are up on the slide. And as always, just a final caveat, this is only some general advice. If you'd like any specific advice on a scenario that you're dealing with, then please feel free to contact me or one of my colleagues in the employment team at Field Seymour Parks, and we'll be more than happy to assist.